Good case, Counsel. All right, the last case on our docket this morning is Country Club Homes of Florida, Inc. Versus Flagler Fire and Rescue et al. Steve, when you're ready, sir.
Good morning, Your Honors. May it please the Court, Carlos Cabrera on behalf of the appellant, Country Club Homes of Florida. I would like to reserve 5 minutes for a rebuttal, please. Your Honors, the sole issue on appeal here is whether the notice of voluntary dismissal filed by Country Club Homes effectively divested the court of jurisdiction to enter an order of dismissal with prejudice thereafter.
I'd like to talk just briefly about the timeliness of the appeal as it relates to, Palm Coast. The trial court grants Palm Coast motion to dismiss with prejudice after all of these arguments specifically were raised. The jurisdiction argument was raised. Apparently, as best I can gather, the lawyer for Palm Coast submits an order to the court. The lawyer for Flagler submits an order to the court. The order for Palm Coast says with prejudice. The order from Flagler says without prejudice. Is that right?
No, both orders are with prejudice. The orders that were submitted to the court were with prejudice.
The December 24th order with Flagler wasn't without prejudice?
It was with prejudice, Judge. Both of them were.
Right. Well, if this is argued in December and an order gets entered, why isn't the reasonable time frame the 30 days for filing an appeal?
Judge, I submit to you that the 30-day time frame doesn't necessarily apply here because we're not looking at 1.540B1 motions. We're looking at 1.540B4 motions, which deals with orders that are void, judgments that are void.
The concept of that is that people should be free to attack those types of judgments. Very often they don't even know that they were entered. Here, you knew that a judgment with prejudice was entered against your client, and you knew that, and the argument had been raised and argued by the trial court, you don't have jurisdiction. And so a final order of dismissal with prejudice gets entered, and you don't appeal it. You just wait, and you end up going to trial on the related action, and then come back with after the appeal. You do appeal the Flagler case, I thought, timely, and file a motion to vacate, and then appeal the motion to vacate within the 30 days. And it seems to me that the purpose of the rule protects those who don't know about these issues, and not those who are very well aware and who have argued it.
Well, Judge, we knew that an order was coming, an order with prejudice was coming. We didn't receive the order entering the dismissal with prejudice. Unfortunately, that really wasn't raised below, wasn't argued below, but that is in effect what happened. We were waiting for the order to come in. It just never came in. We appealed the other one, and when we realized what was going on, it was just too late to raise the purported untimeliness. Nevertheless, we believe that under 1.540B1 B4 and this court's decision in Greasel versus Gregg, it really doesn't matter, because when because an order that is void has no effect whatsoever. This court said in Griesel versus Gregg, a judgment
But you
alleged...
still have, you don't have an unlimited amount of time to raise that appeal. It's got to be a reasonable period of time.
Well, I would agree with you if we were talking about 1.540B1 motions, which has a limitation of 1 year, a reasonable time. B4 doesn't have that limitation. The rule doesn't give it a limitation, and this court held that, and I quote, a judgment alleged to be void may be attacked at any time because the judgment creates no binding obligation on the parties, is legally ineffective, and the nullity. The citation to that is 733 Southern 2nd, 1119. And not only that, this court has also held in Penyon Development Group versus Love, where the judgment is void, the trial court has no discretion but is obligated to vacate the judgment. It's our position...
You could have waited 15 years to raise this.
Judge, I know that that's not what happened here, though. It was just relatively a couple of months, I believe, is what actually happened. It still was within a reasonable time given the circumstances. It's our position. So it wasn't a situation where even a year had passed by, which under 1.540B1 would still be okay if it was within a year. Here we didn't even go beyond that point. We filed the motion to vacate based on 1.540B4, and we believe under the two cases that we cited in the briefs and I've just read to you that we're definitely okay with regard to the timeliness issue. And there's no question that the order was void. The Florida Supreme Court held in Curbelo versus Ullman that an order entered when the court doesn't have jurisdiction is void.
Right, well, but there are exceptions to that, which is if serious prejudice can be shown, which apparently, was the argument made. So why don't you address that issue?
Sure. Judge, you're correct. I mean, 1.4208 guarantees a voluntary dismissal without a court order by serving a notice of voluntary dismissal at any time before a hearing on a summary judgment motion or, unless the exception applies, which is whether there's serious prejudice. Here, let's look at what serious prejudice means. The case law under Ormond Beach, this court said that serious prejudice is where the defendant is entitled to receive affirmative relief or a hearing and a disposition of the case on the merits, has acquired some substantial rights in the cause, or where dismissal is inequitable. First, addressing the first part of the rule, which says, was there a hearing? Let me take a step back. Ormond Beach, as I read it, basically has a two-pronged test, and that is, number one, whether the trial court held a hearing on the motion for summary judgment prior to the notice of voluntary dismissal, and two, whether the defendant was seriously prejudiced. Taking the first prong first, here there's no question there was no motion for summary judgment heard.
Well, their argument is that this was in the nature of summary judgment.
I understand that that's their argument, but I don't think that it's a valid argument because a motion to dismiss tests the sufficiency of the pleadings. A motion for summary judgment takes into consideration the evidence, applies the law, etc. I think it's different.
Well, what was the basis of this motion to dismiss? Was it failure to state a cause of action, or was it sovereign immunity?
It was based on sovereign immunity and subsequent tortfeasor doctrine. And I will address that in just a moment, if I may, Judge, because I don't think that that is dispositive of the issue. Here, even if the motion to dismiss is considered to be the equivalent of a motion for summary judgment, the notice of voluntary dismissal was served before the December 19, 2008 hearing on the motion to dismiss. Even though there was a hearing on Palm Coast, a hearing on November of 2008, that hearing was continued until December 19.
Well, didn't the judge just say, I'm going to hold off ruling until Flagler has their hearing?
He said that, but he also said that he was going to give the opportunity to country club homes to address this issue regarding the subsequent tortfeasor doctrine. And that, I can point out the page number if you like in the transcript. In fact, why don't I do that? This is in the appendix, page, tab A, page 38 and 39. The court said, all right, well, in that case, I will rule on the 19th of December. That gives you a little bit more time to explore their alternative. It's not just an alternative theory of a subsequent tortfeasor being involved in this case. So he gave Country Club Homes the opportunity to address this issue. So it's our position that the hearing wasn't completed, it was moved to December 19th. And because the notice of voluntary dismissal was served on the 18th, it still met the requirements of the rule, and therefore the voluntary dismissal was effective.
As an aside, if they're correct on their sovereign immunity argument, all of this is academic, isn't it?
I'm sorry?
If they're correct on their sovereign immunity argument, all of this is academic.
Not necessarily, because I don't think they're not correct on their sovereign immunity argument, and I'll get into that right now, Judge.
Well, no, let's go back and finish up with the argument as to whether there was serious prejudice.
Okay, well, I think that that's where I'm going. Their position that there was serious prejudice because they were entitled to a hearing and a ruling on their motion to dismiss, which was based on sovereign immunity, and that the contribution claim was barred because, or under the equitable subrogation, that the contribution claim was barred under the subsequent tortfeasor doctrine, and instead the correct cause of action would have been equitable subrogation filed after the case was over. In other words, they were taking the position that the contribution claim could not be tried at the same time with the main action. Addressing the sovereign immunity issue first, the case law is clear that there is immunity for for planning level decisions.
But how is this any different than the Palmer case?
It's different because in that case it dealt with how the fire departments put out a fire. That's not what we have here. Here it was the decision of the...
They opened the windows in Palmer, which caused the fire to accelerate and burned up all the guy's property.
And which is different in our case. In our case, the fire department arrived. They put out the fire. They made the decision, the fire is over. It's done, we're leaving. They leave. Many hours later...
You think that they should have kept someone there? Is that their negligence?
They should have made sure that the fire was actually extinguished before they left. And I don't know if they had to keep someone there.
And your distinction is under the Undertaker's doctrine? Is that what you're relying on, that Wallace case?
I did not consider the Undertaker's doctrine, Judge, but perhaps it is applicable. I mean, they did undertake to put out this fire, and then they had a duty to make sure that it was off.
What those cases from the Supreme Court say to me is, when a building inspector negligently inspects or the fire department negligently extinguishes a fire, that's immune.
Again, I think that there's the definite distinction, and maybe I'm not being clear on it.
Well, you've stated a factual distinction. I'd like you to express it, though, in terms of why that makes a difference legally.
Well, sure, because I think what we're talking about, what the court is talking about, are planning level decisions. What I am trying to submit to you all is that the basis of our claim is on an operational.
But there's no planning level in Palmer. They're opening. It's not like they have a meeting and discuss whether opening the windows of the upstairs is going to be a better firefighting technique. In the course of putting out the fire, they used a technique that was outside the norm and resulted in damage. And the court in Palmer said no liability.
Right, again, because that deals with how the fire department put out the fire. How do you put out a fire? There's no liability. There's immunity for. And
yours deals with whether they keep someone there.
Not necessarily whether they keep someone
there. Was extinguished.
Not necessarily to keep someone there, but if once they undertook to put out this fire, to make sure that it was extinguished, completely extinguished, so that it doesn't rekindle. It rekindled twice on 2 separate occasions.
So when firefighters go out to a brush fire and, put it out as best they can, if it rekindles, they're liable.
Well, they're not immune.
Or they're not immune.
Under those circumstances, I'm not really sure, Judge. I think here it's different. A brush fire, I don't know what's being damaged necessarily, or someone's property. I really don't understand. I don't see
Someone's
the
house
analogy.
burns down. The fire, reignites and burns down someone's house.
Potentially, if they didn't extinguish it completely, potentially. I don't know under those circumstances. I think it's different here. I think
They didn't put enough water on it or something, right?
I'm sorry?
You're saying they didn't put enough water on it, or they didn't?
I don't know the specific mechanics of putting out a fire, but
I'm trying to find out what your theory of liability is. Your theory is that they didn't douse it enough, right?
they didn't completely extinguish it. They undertook the duty to do so.
The holding that you advocate is that if a fire department negligently extinguishes a fire, they're not immune from liability.
In circumstances where they don't extinguish it, where they leave thinking it's extinguished, when in fact it's not, I submit to you that yes, there should be liability for that. I think it's different than going into a home and deciding to open a window or break down a wall, which caused more damage. I think that's different than...
Why is one plan and the other operational? I'm struggling with that distinction.
I guess maybe another way to look at it is for example, you know, if the municipality decides or the county decides to place a traffic light in a certain area, that obviously is a planning level decision. The maintenance of that traffic light is obviously operational, and there would be a liability for that. I think it's the same thing.
Have you looked up my cases that I've tried?
I'm sorry?
Have you looked up cases I've tried?
Not on this particular issue,
Right.
Judge.
I had that very issue. Okay.
Okay. I think I've run out of time, but I definitely would like to...
All right, want to say the rest of the rebuttal? Sure.
Yes, please.
Yes, sir.
Ms. O'Leary, where is the evidence of serious prejudice? I mean, we start with a presumption, or with almost a rebuttable presumption that if they want to dismiss a case, they can dismiss a case. The rules allow for them to do that. So there are very narrow exceptions to that right, and you're claiming serious prejudice as an exception to that general proposition, correct?
Yes, in part.
Where is that serious prejudice? What is that? Where's the record evidence of that?
Well, it's just an issue of law. There is no record evidence because, as you know, the complaint was filed against the city. The city was served, let's see, I believe it was in September of 2008. The city did not answer, but instead filed a motion to dismiss based upon sovereign immunity, as you've just discussed. So at that point in time, there was no evidence. The ruling was based on the four corners of the complaint and the law.
Well, what is the argument in terms of serious prejudice?
That the city was immune from suit. It had no duty to fight the fire in a specific manner, and B, assuming there was a duty, it was...
Isn't that every case? I mean, can't you make that type of argument in any case where you file a motion to dismiss?
Well, as actually counsel for Country Club indicated at the hearing, and I can give you the page site if you give me a moment, but page 34, sovereign immunity normally is not raised in a motion to dismiss, but in this particular instance it was something that was apparent from the face of the actual complaint, and therefore it could be raised here, because the whole allegation of the complaint was that the city basically didn't fight this fire the right way. And in that instance, given the Supreme Court authority, which Your Honor has been discussing with the opposing counsel, that argument could be raised. The Supreme Court has definitively said there is no duty to fight a fire in any particular fashion. and fighting the fire is what was at issue here.
But certainly you're not taking the position that a fire department can never be liable for negligence.
No, I mean, if they do something completely out of the norm, which actually did happen in Palmer when they opened the window and let the oxygen in the air, and that caused the fire to burn further, they found that was okay. I suppose if they did something really extreme that completely, was wrong as far as firefighting technique, then that may be
But they didn't get
the
it. They didn't get a
situation.
chance to present that. I mean, perhaps they could have had experts come in and testify that what the fire department did in this case was completely beyond the norm of firefighting techniques.
Well, I know argument of counsel is not evidence, but at the hearing, at one of the hearings, and I'd have to find the site to the record page, the attorney who was representing Country Club at that particular time stated the fire was out. The fire department left. The fire rekindled. The fire department came back. The fire was then put out again. So she stated this on the record. So apparently they had knowledge of that particular fact, that it was indeed out twice. And for reasons unknown to anybody, it rekindled. Now, again, I know that's not evidence, it's just argument of counsel, but they basically acknowledged that they knew the fire had been put out twice.
So the serious prejudice to you is having to defend the suit?
Yes, and also I think it's important.
Anything else? Any other arguments as to what the serious prejudice would be?
Well, I think it's important to note that at the time that all this was occurring, when the hearing on the motion to dismiss was held initially, it was November, and then the second part of that hearing was in December. This case was set for trial January 5th, I believe it was, the first week in January. So at that time, the city was scrambling to put together a defense, to come up to speed. This case had been going on for years, and the city was not involved. The city was trying to get prepared if it were indeed forced to.
But the case wasn't an issue in terms of the city, was it?
Well, the city still needed to be prepared with what was happening and to understand. At that point, they were trying to name the city as the Fabry defendant. There were all sorts of other.
That was denied.
I'm sorry?
That was denied.
That was denied after the initial hearing when the city first argued, we are prejudiced by
Well,
this.
that can't be prejudice then, since it was denied. So what is the I'm trying to understand all your arguments in terms of serious prejudice. The fact that you'd have to defend, the fact that time was short.
The fact that the city would have to defend a lawsuit that ultimately the city believes the city would be sovereignly immune from. That is the main argument.
All right.
But also, Your Honor was discussing this with the opposing counsel. Here, they did not appeal the order dismissing the city. For whatever reason, that wasn't done. They appealed the order entered with regard to the county, but not with the city. And then they tried to correct that error by
The
filing.
counsel indicates that they never got a copy of that order. Is there anything in the record?
The order itself indicates a copy was sent to, at the time, it was Mr. Lundy of his law firm that was representing Country Club. And the order indicates a copy was sent to him.
Was there ever an argument made either at the motion to vacate or any other time that they had not gotten a copy of it?
No. No, the first time that argument appeared was in the initial brief. And so had that argument been viable, they should have raised it sooner. Plus, you had attorneys for Country Club at the actual courthouse beginning of January for several days having a trial on this matter. When they received the order on the county's motion to dismiss, I believe that, if you give me a moment, the date of that was January 13th. So you would presume perhaps that maybe they looked to see was an order entered as to the city. Because if they had learned at that time, they could have still filed a notice of appeal. They were within the 30-day time frame.
I had thought that the court entered two orders on December 24th, one that dismissed Flagler without prejudice and one which dismissed Palm Coast with prejudice. Am I incorrect on that?
Yes, Palm Coast was dismissed in December with prejudice. Flagler was not, that order was actually not entered until January.
All right. Was there a second order entered on December 24th as to Flagler?
As to Flagler, I'm not sure. I do not believe so.
Okay. All right.
So, my position is, well, let me back up. Rule 1.540B.
Are you raising that suggestion that it was an untimely appeal?
Yes.
But have you raised that in your brief?
Yes, that they were using 1.540B as a means to circumvent the fact that they did not timely appeal. That is raised in my brief. And the main case that they relied upon, the Griselle case, in that case, the Griselles did not have notice of the court order. And so that case addressed the issue that Your Honor spoke about, where there's just no notice. And so there is time for a party who doesn't receive the order to then go into court and get that corrected. But here, opposing counsel or country club's attorneys were present at the hearing on November 19th. They knew what was going on. They knew the court had continued it. I'm sorry, it was November 25th. They knew the court had continued it to December 19th. They were present at the hearing on December 19th. They knew the court's oral ruling. They knew opposing counsel was submitting an order. They then were present, at the actual courthouse for the trial in the main action. They received the order on the county's motion. So they had notice. They knew what was going on. They could have just inquired simply by walking into the clerk's office while they were there. Hey, what's the status of the Palm Coast order? We received one with regard to the county, but not with regard to Palm Coast.
If the order is void, why can't you challenge it in a motion and then appeal after the motion is denied?
Well, we believe that the rule was intended to address a situation where there's simply no notice, which renders the order void.
A void order can nevertheless not be challenged if it's not challenged within 30 days.
Well, we would argue it's not void because it should be treated as the actual motion should have been treated as a motion for summary judgment or akin to a motion for summary judgment.
It's not void, but if the order is void,
if the order is void and you
can
have
challenge it at any time, right?
a strict reading of the rule, and yes, that's what the rule states, that a void order can be challenged.
Doesn't make any difference whether they had notice of it or not, right?
If you strictly interpret the rule.
If it's void, right?
Yes. Yes, but we suggest that case law has interpreted that to mean that in situations like this one, we suggest that the court can find that it wasn't void because it should be treated like motion for summary judgment, given the nature of the arguments, and also that they had noticed this wasn't the type of situation that we believe the rule was designed to protect.
Do you have any case law that supports that proposition?
Unfortunately, no. This seems to be a quite unique procedural case, as I'm sure you all have concluded yourselves. Let's see. I think that addresses all the issues that I wanted to mention. If the court has any other questions? No? Thank you. We request that you affirm.
Thank you.
May it please the court. My name is Cindy Townsend, and I represent the other appellee in this matter, Flagler Fire Rescue. And Judge Cohen, to answer your question about whether a second order was entered against Flagler Fire on December 24th, no, it was not. The only order entered with respect to Flagler Fire was on January 13th, and that was with prejudice as well. I'd also like to address, you had asked...
That was timely appealed.
That was timely appealed, correct. The focus of Flagler's argument was with regards to the prejudice issue. And I would like to point to you to Ormond Beach Associates. I know that you've read that case. And in that case, this DCA determined what it is a defendant has to show that he has been subject to severe prejudice. And a defendant can demonstrate serious prejudice, such as where he is entitled to affirmative relief, which we have argued is based on our entitlement to sovereign immunity, as has been discussed by the court, a hearing regarding that, and a disposition of the case on its merits. And as Ms. O'Leary pointed out to the court, we believe that the decision whether the fire was properly extinguished and that the firefighters could leave the residence, that is exactly the type of discretionary, judgmental decision that is entitled to sovereign immunity. And I think that the difference with Ormond Beach and the instant case is that in Ormond Beach, they were arguing about the entitlement to an award of fees and costs. And in that case, it was not dealing with a substantive issue such as whether the case could be dismissed on its merits, and was not dealing with sovereign immunity. And even if the notice of dismissal had not been filed in this case, I think that Flagler and Palmcoast would have prevailed on this matter because of the issue of sovereign immunity. So that distinguishes it from Ormond. But Ormond we don't rely on Ormond because the facts are analogous. We've merely cited to it to say that there is a recognized common law exception to the broad scope of 1.4208. And I think here we have shown that because of sovereign immunity, we would have been entitled to affirmative relief, a hearing and a disposition of the merits, and that is our position that demonstrates serious prejudice.
All right, so anytime someone comes in and says we would have won, that's serious prejudice.
No, Your Honor, not every time, but I think it's based on the facts of this case, and it's based on the fact that sovereign immunity, which is clearly established for exactly this type of situation, and this is what the court was dealing with and what we are dealing with now. I think in this situation, that's where we are able to establish serious prejudice.
But isn't there a difficulty in doing that on motion to dismiss as opposed to allowing some exploration into the facts?
Well, I think based on the way that they pled the allegations against us in the third-party complaint, they said that we did not properly extinguish the fire, that we allowed it to rekindle twice. And I think based on those allegations, that's why we were able to say, on those allegations, there is no way you can hold us liable for those actions.
Well, what if the firefighters, they extinguish the fire, there's still some flames or some, they can see some coals, burning, and so they say, well, this is extinguished, it's good enough, and they leave.
Well, I think that's questioning their decision, and that is what these cases Palmer protects. It's whether their decision, it doesn't have to be a right one, and if it's a negligent decision particularly, that is what is protected by sovereign immunity. And it's their decision
But you're not suggesting that firefighters are immune from all liability regardless of what they do.
No, I am not. But I'm saying that based on the allegations in this complaint, on what is on the record before us, we are entitled to sovereign immunity.
But there aren't real facts other than the pleading, correct?
Correct.
All right. Okay.
I have no further questions.
All right, thank you very much.
Thank you.
As counsel has just argued, there's no prejudice. They suffered no prejudice. The case was bifurcated. The trial court specifically issued an order, which is part of the record on page, let's see, it's volume 3, pages 451 to 452, when it granted Country Club's motion for relief to file a third-party complaint. It said, if the third-party defendants, Palm Coast Fire Department and Flagler Fire and Rescue, are not prepared to try the case, that their involvement in the case shall be bifurcated so as not to delay this matter. So, number one, having to try a case is not prejudice, and I think there's case law to that effect. Number two, they weren't required to try the case in 2 or 3 months, or however long it was. The case would have been bifurcated. So there's just simply no prejudice. With regard to the untimeliness of the appeal, I think the better practice would have been to probably have filed a notice of appeal, or once we discovered that the order was not received and we found out too late.
Well, but we have no record evidence that the order wasn't received. It wasn't raised at the motion to vacate.
Understood.
So there's no record evidence of that.
Understood. All I'm saying is it would have been a better practice to have done that. However, we feel that under the case law, and because the order that's
Do you have
being
any
appealed...
case law in a situation where, the issues had already been framed, that said, well, it doesn't matter, you can take as long as you want to appeal?
Well, I would refer the court to the two cases that were cited in the brief. I don't know if it specifically addresses the court's concern, but Penyon Development Group versus Love and Greisel versus Gregg, I think those are the two cases that really address the issue when you can attack a void judgment. I don't specifically recall the facts of those cases, how involved into the case they were, but I believe that those were the only two cases that I could find that dealt with this issue. But given the circumstances in this case, I believe that we were able to file the motion under 1.540 and that it was timely appealed once we got an adverse ruling on that motion.
Can the fact that they're not allowed to effectively rely upon, they're going to have to litigate a clear claim of sovereign immunity, can that be prejudice in your view?
Having to try a claim?
Yeah, having to litigate when, based upon the pleadings, they claim that they're entitled to sovereign immunity.
There's no prejudice, Judge, and particularly under the procedural posture of this case, where we were on a motion to dismiss. There's been no time to do any discovery, any way to develop the facts. All we had were some allegations, which, by the way, if there was some defect in it, the normal course of procedure would most likely be to allow leave to amend that complaint, which obviously we were never even given that opportunity. With regard to the contribution claim, very quickly, they're taking it...
No, has he answered your question?
I'm sorry, did I answer the question?
You're over time, sir.
Okay. Thank you very much. I would ask support
All
to...
right, thank you, counsel. Well-argued case. Or being recessed.